So this panel is just a natural follow-on to the last one. This panel is on privacy, data security, and trade. Oh, I guess I need to wait till you guys get mic'd up. Policy choices, and we have a great panel to discuss this. Commissioner Julie Brill of the FTC, Luigi Gambardella, the chairman of the executive board of ETNO, Erica Mann, managing director for public policy of Facebook, Bernie McKay, the chief public policy officer and vice president for global corporate affairs at Intuit, and Alan Raul with Sidley in Austin. There is obviously a lot going on in the world of privacy, and obviously the controversies swirling about the various NSA revelations of the revelations concerning the NSA surveillance programs are at the top of the news on almost a daily basis these days. The purpose of this panel, however, is not to really get into the pros and cons of these surveillance programs and to discuss those issues. However, the NSA revelations are going to have repercussions on what happens, and are already having repercussions on what happens in terms of commercial privacy regimes, and particularly in the transatlantic context. And I would like to get into that at some point in this discussion. In the last panel, Carlos talked about how similar the European and the U.S. Approaches to privacy were, I think, in contrast to other countries like Russia and China. I'm actually going to focus a little bit on I'm going to leave Russia and China out of this and focus on some of the differences between the European and the U.S. privacy approaches. Which are not trivial. In Europe, privacy is considered a fundamental right, which is reflected in the EU draft General Data Protection Regulation that's currently under consideration. And the U.S. has adopted a different approach, which now is increasingly relying on multi-stakeholder processes, such as the ones at the W3C and at the NTIA, that are attempting to develop consensus standards around which various groups can coalesce. So the broad theme of this conference concerns the effect of policies on creative destruction and innovation and growth. And relevant to the new world of big data that the chairwoman Ramirez was talking about yesterday at lunch, data protection policy is going to have a potentially large effect on innovation on the internet and elsewhere. So let me start out by posing a question to the panel. Let me start out with Commissioner Brill. What are the critical differences between the European and U.S. approaches to privacy and data security, and particularly insofar as how they might affect innovation?
Sure, and thank you so much, Tom, for having me here. And this is my second year here, and I really enjoy this conference a tremendous amount. It's the ideas.
We appreciate your coming.
Great.
So.
Okay, blah blah blah. So before we leave what Carlos Lopez Blanco said, I think it's worthwhile just spending a moment before we get into all the differences to talk about the similarities between us and Europe. I mean, there are a lot of differences, and we're going to probably spend a lot of time talking about that this morning. But let's first recognize, and this is something I do whenever I speak with my European colleagues, and I speak with them quite a lot. I am in a lot of contact with the Article 29 Working Party. I'm in a lot of contact with the International Conference of Data Protection and Privacy Commissioners because I'm on the executive committee on behalf of the FTC. So, you know, what I like to point out to them is that there are a lot of similarities between our regime and their regime. Some of the similarities stem from the fact that we are both, on both sides of the Atlantic, trying to respond to the enormous change in technology that both societies or all societies are now facing, and trying to come to terms with how do we do appropriate privacy regulation in this rapidly changing environment. So some of the shared concerns that you'll see if you examine the proposed regulation closely, you'll see privacy by design. It's something that we have talked a lot about at the Federal Trade Commission, both in our big privacy report and elsewhere. And you see it as a theme within the proposed reg. Increasing transparency, whether it's through data brokers or other players in the ecosystem, again, a theme that you see on both sides of the Atlantic. Data accuracy, data security, increasing consumers' control over data, children's privacy. There's a provision or a portion of the proposed reg that would enhance protections of children, largely under 12, I believe. Maybe it was under 14. We didn't quite get the exact. 13. It is under 13?
Yeah, it changes.
It has been changed. Okay. Yes. So 13 and above, there's some protections, but the larger protections are in the same target area just about as the Children's Online Privacy Protection Act that we have on this side of the Atlantic. So before we get to differences, let's also recognize that there are some similarities. Okay, differences. I think the biggest difference is largely in implementation of how we implement our privacy protections. Yes, the fundamental rights versus non-fundamental rights is an issue, although as I like to tell my European friends, we do have the Fourth Amendment here in the United States, and the Fourth Amendment, although we don't enforce that, the Fourth Amendment is a fundamental human right. We don't use that terminology, but that's kind of what it amounts to. But in terms of commercial privacy protection, I think the biggest difference is in implementation. And what you see on our side of the Atlantic is our enforcement work at the Federal Trade Commission, as well as at the states, as well as at HHS and some of the other agencies that are deeply involved in privacy, our enforcement work sets a floor for appropriate practices that businesses can engage in. In other words, we say, if you cross this line, we're going to go after you, and we will bring an enforcement action. And some of our enforcement actions, as many of you know, have been quite tough, as Erica and her colleagues are aware. And then what we engage in, so we set a floor of activity, and then we engage in a large amount of policy work that's designed to encourage businesses to focus on what best practices are in certain areas. So in addition to our big privacy report, we've done a report on facial recognition. We've done several reports on mobile privacy, including mobile app disclosure, as well as kids apps and the kinds of disclosures that are out there for that. We are working on a data broker report based on our 6 Bs, and we're going to do an upcoming workshop and undoubtedly a report on the Internet of Things. These are designed not to set up law enforcement criteria. That is, these reports are not designed to establish a baseline over which, if a company crosses, we will go after you. But rather, they are designed to elicit and discuss and put into the sort of consciousness of the telecom community, the technology community, best practices, what you ought to be thinking about as you're thinking about how to improve privacy protections. So I see that as the way we do things here in the United States. Now, without really commenting too much on exactly how things are done in Europe, I do think it's probably fair to say that we do enforcement really well here. And I certainly have spoken to a lot of businesses. I have a real open door policy, and I'll talk to anyone who wants to talk to me about any of the work that we do. And in terms of the businesses here on this side of the pond, I know that there's been a certain amount of concern as to whether the EU approach is too prescriptive, may provide less flexibility to innovate, and may lack effective enforcement, particularly when it comes to the multiplicity of regimes who may engage in different, may end up with different results in terms of their enforcement work. My feeling is that our EU colleagues get this, and that some of the work that they're trying to do through the proposed reg is designed to address some of these issues, particularly in terms of inconsistent enforcement results. That's one of the things that you see front and center as being addressed in the proposed reg. So, that's what I see. I mean, that's what I see as similarities and differences.
Thank you. Erica, you first of all you're in Brussels, you have broad experience in European government. You work for a company that is at, point zero in terms of privacy issues, is a big, how do you see the differences, and you work for a company that's a U.S. company, but obviously a global company. How do you see the differences between the two regimes and the effect on innovation? I sometimes get the impression when I listen to Europeans discuss privacy issues, big data, and everything, that they don't kind of confront in any direct way the fact that there may be trade-offs.
I think Julie is right. When you watch the process about the data privacy regulation over the last, 1.5 years, you can see that things developed. Now we see that the Snowden affair is overshadowing the most recent discussion, so somewhat we start fresh again, and hopefully there will be understanding in the upcoming months that that there are two different stories, and one shouldn't confuse the two items: the data privacy discussion and regulation, and the NSA debate. So I think we have seen progress. But there's one thing you always have to take into consideration when you talk about the European Union, and this is true for all legislation, not just in particular for the data privacy regulation, that the principal philosophy is that one likes to have in Europe a horizontal approach, a very detailed approach, and something which is not only or primarily principle-driven. And this is true in all areas. And this reflects the way the European Union must shape its policies, because it's still a quite young, organization, and it needs to find a way to what Europe, argues, to build a single market, so to overcome the national barriers which still exist in certain ways, and this is then reflected in the way the regulation is made. So one cannot be surprised that there are differences, but like Julie said, there are similarities as well. Right. So I would caution and would say, if we get it right, the differences can actually be sorted out, because the interest of companies is so broad, and it's true on the US side and it's true on the European side, that we have enough and sufficient common ground. And the same is true for the users and the customers. I mean, they use services from all over the world. They use European services and they use American services. They are interested in, not experience barriers or unnecessary barriers. So I think it is manageable. For us, for Facebook, the situation is even, more fascinating, because we have two regulators. Because we have our international headquarters, which is sometimes forgotten, in Dublin. So we are governed by the Irish data privacy officers, which audited us recently, and we are, to a large degree, governed by the FTC. So we have two regulators, and we are a global service. So you can imagine that we have a great understanding how both sides work and function, and we have a great interest to find as much as harmony between the two sides, and not to see differences popping up, which then will just affect us, but will affect our customers as well.
So, taking off from something that Erica just said about Vivian Redding, I think maybe this was in her New York Times op-ed or someplace else, but at any rate, she wrote that PRISM is a wake-up call for those who have been blocking the EC's proposed data protection reforms, and suggested that the answer to all those problems is implementing those. Luigi, is implementing those reforms the answer?
First, thanks a lot for the invitation, because for me it's always a pleasure to be here in Aspen, such a beautiful place, and to attend such interesting event. I think that if I may also try to answer to the question that you have asked also before on the differences between Europe and US. I think there is one big difference that we should never forget. US is one country, Europe is not. We have 28 member states. And so this makes a huge difference. And we have to understand that the fact that we are having EU data protection reform is also because we need to have an harmonization within Europe. And the regulation is an instrument which allows, at European level, to have the same rules, because we have also a problem with implementation in Europe in the different countries. I make just an example in the data protection reform is the issue of one-stop shop. That is one of the most controversial. And you know that on this, member states consider that this principle would mean that they could lose power, could lose the control. I know that you are aware of what this principle does mean. Basically, the principle implies that only one data protection authority is responsible for taking legal binding decisions against a company. And the data protection authority is determined by the company, the main establishment in the union. So, and I think that this aspect is very important. The EU data protection reform is very important, first, to harmonize within Europe the data protection rules. Now, I agree that there are similarities, but there are also important differences. And there are commercial differences. In the US sector, you know that players are allowed to do profiling for the identification of consumer behavior and preferences for the purpose of targeted advertising, with the only mandatory requirement of informing users about the way in which their personal data are collected and analyzed. In Europe, by contrast, this activity can be undertaken only after having obtained the user's informed consent. This is a big difference. Now, from our point of view, what is important? What we expect from this? We always say and we always repeat, we need a level playing field. But this is not only for us. This is also for our customers. It's for the consumers, for the user. Because as Erika was saying, when you use the internet, if one European consumer is using the internet, he is not aware whether the server of the service that he is using is in Europe, in the South Europe. He doesn't care. And he wants to be sure that he has the same level of protection, independently where the server is. So, and this is the point, and this point is very important for us, and this element of, let me say, extraterritoriality, I think it's a very important one.
So let me take off from that. So that would be a potentially quite significant change, because that's currently now there's the safe harbor that that allows the two areas to essentially maintain their separate regimes, but the new proposal obviously would apply to organizations outside the EU if they process data of the EU residents. Now, obviously, you favor that provision. So, let me ask a couple of the other members of the panel what they think would be the effect if that provision was adopted. Let me go first to Bernie and then to Alan.
I think we need to sort of step back. There's an interesting observation that I heard in Rome last fall at a conference at John Cabot University. Professor Pietro Paganini, he's a member of the board of the European Privacy Association. And he pointed out that small business is the backbone of the Italian economy, actually the backbone of every European economy, of each of the member states, and pointed out that in Italy, the average small business is made up of 4 people: the mama, the papa, the son, and the daughter. And the dog. But that the challenge is to try to find a balance in policy that accommodates not business versus the consumer, but the 2 distinct definable interests of the consumer. One is for protection and safety, and the other is for economic empowerment. And the ability of that 4-person family business in a village in the average neighborhood town in Italy to not just address customers on their block, their neighborhood, village, town, maybe the next town, but a customer in New Zealand or Brazil or Canada. I may not sound like it, but I'm actually an Irish citizen. And where my family comes from, in North Cork and in County Armagh, up in Ulster, the small business is the heart of every village and town. And I can tell you from working with local members of the Irish Parliament, the Dáil, for example, in North Cork, Owen Collins, she has the view that without the internet, without the tools of 21st century economy, her constituents and the small businesses that are the backbone of the towns in North Cork, like Mallow, will be left behind, rather than being a vital part of the new economy. So what seems to get lost, and unfortunately, the whole issue of governmental data collection in combat to international terrorism, which is not unique to any one country, but is certainly true of any part of the world where terrorism has inflicted pain and violence and death, whether the United States or Europe in this case. Governments have policies and practices and procedures which rarely get talked about in public. And some stuff has been talked about in public in the last month, and there's all kinds of political controversy about it. But the fact is that this is a global fight, and almost every country is involved in some manner with their own policies. While that all has to be addressed in public policy circles, we have to also come back to, as we protect the lives of our citizens and keep them able to have businesses and keep them able to enjoy life and freedom from fear, that the policies in which they will grow and thrive and provide a better life for their children, and then their children have a better economic circumstance and jobs and employees if it's a small business, and address a bigger market, policy is going to have to balance the 2 competing interests of that same single consumer or small business family: protection and safety, and economic empowerment. And if policy decides it has to choose between those, that creates a fundamental problem. And that seems to be the collision course, and it's unfortunate, and it would seem unnecessary. The objective would have to be balance to accommodate both vital interests of the European citizen. And what has to happen is somehow this issue of the national security of each country has to be dealt with in that context, and not so infect the issue of consumer rights, whether they be to a job and economic security for their family, or their consumer protection so that they're not taken advantage of on the global web, somehow we have to accommodate all of those. And so my observation would be somehow we have to take all of this dialogue, all of this debate, and recognize it is not just about consumer protection, it is also about economics and global trade in the 21st century economy, and that it's a complex set of issues, and we can't just discard any of them as being, that makes our head hurt, and we instead need to address them all. Unfortunately, it rarely gets framed that way, and that would be a disservice in the end to the people of Europe and citizens of the European Union and our families and our friends and our neighbors, because I think we have a right to expect balanced policy that affords both of the needs that we have as families and as small businesses and as people.
So let's move in. Let me go to Alan. Let's kind of move into that. Obviously, we've mentioned it several times, the TTIP negotiations, and so they're going to, they're obviously going to be important in this area. There's a lot of trade in digital goods, and there's cross-border flows. So the differences in the European and the U.S. approaches to privacy are going to get all wound up in that. So, Alan, how do you think they're going to be addressed in the context of the trade negotiations?
Well, the first thing is that we need to recognize that right now there is an agreement on both sides on a metaphysical point, which is fundamentally wrong. And that is that in the EU, privacy is an unassailable fundamental right, and in the United States it's not, with the exception that Julie mentioned about the Fourth Amendment. And really, that is not only misguided, perhaps even disingenuous, but I would submit that it really is responsible for much of the conflict, the bilateral conflict between the EU and the US on data flows and privacy. It is true that privacy is denominated as a fundamental right in the European Union and further solidified in that status under the Lisbon Treaty. But what is not often examined and is too readily acquiesced in by the U.S. side, including U.S. governmental negotiators, is what the implications of its being a fundamental right in the European Union are. There are 50 or so, maybe exactly 50, fundamental rights in the European Charter. Privacy, data protection is one of them. And by the way, they are distinguished, privacy and protection of personal data. And it is not an absolute right. It is a right to be balanced against other fundamental rights, which, by the way, include the right to conduct a business and the right to property, as well as the right of freedom of expression, freedom of worship, and also the right to the efficient administration of government agencies. So that's where privacy stands, right next to efficient operation of government. And so that's only to say that the Europeans recognize a lot of fundamental rights. To invoke the mantra or the shibboleth of privacy being a fundamental right does not tell you anything other than it's very important, as it is in the United States. We have the Fourth Amendment. Under the Privacy Act, Congress recognized privacy as a fundamental right. They used that term in the legislative history, dating back to 1890, with Brandeis and Warren, the right to be let alone and all the privacy torts. Privacy is very, very important in the United States. Now, when I say privacy is not an absolute right and that it must be balanced, I am not simply citing, my speeches on this, my writings on it, Chris Wolf's or others. I am citing Vivian Redding in her transmission of the new draft privacy regulation to the European Parliament, where she says outright privacy is not an absolute right. It must be balanced in proportion with these other rights, including the right to run a business. So this is not an argument that I'm making about privacy not being an absolute fundamental right, and picking up on what Bernie said, there must be balance. The balance is recognized on both sides of the Atlantic in setting policy, but when the data protection authorities, the data protection supervisor, and indeed even Vivian Redding, who's the vice president in charge of the Director General of Justice responsible for privacy, very often when they are asserting policy positions vis-a-vis the United States with regard to our ostensible inadequacy, they invoke the shibboleth of privacy as a fundamental right. So let's all disabuse ourselves of the notion that that means that it's more important in the European Union than it is in the United States, because I don't think that's true. Well, there are some distinctions. Luigi mentioned the opt-in requirement for profiling, and there are some other regards. In many ways, the United States is ahead on privacy. Certainly in enforcement, Julie Brill mentioned how we do privacy enforcement and data security enforcement really well. We've got not only is the Federal Trade Commission hot on the case, nobody wants to get in Julie and her colleagues' crosshairs, but we have 50 aspiring governors who are attorneys general looking for aggressive opportunities to enforce privacy laws, and it is their leading initiative this year and will continue. I mean, it's been identified as their leading initiative. We have privacy class action lawyers in the United States who are also rather robust in trying to enforce these provisions. And we have data security laws that impose affirmative obligations. I don't know, I'm sure there are others in this room who have either given advice or received advice that if you're signing an agreement for the transfer of data with an entity in Europe, the U.S. requirement, if you only include data security provisions adequate to satisfy the European standards, that's not going to be good enough on the U.S. side, because we have Massachusetts requirements, California, Graham-Leach-Bliley, all sorts of affirmative data breach obligations that impose extensive obligations on us. So the first thing we need to recognize is that privacy is of fundamental importance on both sides, not necessarily greater on the European side. Going to a point that there is a fundamental distinction on, and I will acknowledge this, and I think we need to recognize it, and that is freedom of expression in the First Amendment. Almost all of our rights, privileges, constitutional provisions, almost everything in the United States is really subject to cost-benefit balancing, to taking account of different interests, but we are almost completely absolutist about the First Amendment. And while freedom of expression is a fundamental right in the European Union, it's taken quite seriously. It's trumped privacy in various Court of Justice opinions. The fact of the matter is it's not as absolute as it is in the United States. And in the United States, corporations are entitled to a First Amendment right of freedom of expression, including the use of data.
So you're suggesting that the privacy protections in the U.S. are equal to it, and perhaps in many cases superior to the ones in Europe. Luigi, the implication of what you were saying was quite the opposite, that you want, quote, a level playing field, and that suggests that American companies need to be brought up to the level of the European proposal. So,
yes, if I may, I will try to be a little bit provocative in this sense that if we could agree to have the same rules, we would accept that, because what we cannot accept, what can put the European company in a disadvantage, is to have the same service to the same customer with different rules. We don't want that. If you say that your rules, the US rules are better, okay, but let's have only one set of rules. If we agree on that, I think what is not acceptable that we have two different rules, because these have commercial implications. And this is the point.
May I respond to that, Tom?
Well, actually, both Erica and Julie would like to talk. Yes. So,
who would you like to go first? Alphabetical order? How's that?
Alphabetical order sounds good to me.
I did that at school all the time.
No,
it's totally cool. So I just, what I heard Luigi talk about was kind of a vision towards convergence. And the truth of the matter is, my sense of what is going on in Europe, what is going on here, is that talking about convergence is not going to, I mean, look, ideally, great, but I don't think it's a practical goal for us to be reaching for. I think it would be much more practical for us to be focused on interoperability. Absolutely. And that's the word that we use at the Federal Trade Commission. And I spend a lot of time talking to my European counterparts about respecting the differences, recognizing the similarities, and then talking about how can we be interoperable. And frankly, we have provisions in place to promote interoperability so that there can be cross-continent data flows. Binding corporate rules, and the safe harbor, and some other provisions. The safe harbor, I think, Tom, you pointed out, as a result of some of the revelations that about government sweeping of metadata in order to try to protect our citizenry, certainly has revived, I think, the spirit of some of the folks who are trying to really push through the proposed reg in almost its current form. We heard Vivian Redding say the safe harbor is not so safe. Jakob Konstam, both of Ms. Redding and Jakob Konstam are both friends of mine. I speak to them a lot. Jakob wrote a letter to Vivian, I think it was just last week, questioning whether or not the safe harbor whether or not the Article 29 Working Party members need to look more closely at the safe harbor and whether it can be complied with in light of some of the revelations. So these are, I think, legitimate concerns that all of us should have here on this side of the pond about the safe harbor and whether or not it's going to remain in more or less its current form. Before these revelations about government collection of data here in the United States, we'd received assurances from Vivian Redding and from Jakob and from others, Françoise Labaye and others, that the safe harbor would remain largely the same as it is when the proposed regulation goes through. And I'm about to head off to Brussels in mid-September. I'm going to be going to an event with Danny Sepulveda, newly replacing Phil Verveer at the State Department, to participate in the EU Privacy Day. And we'll also obviously have meetings and talk to folks about their concerns about what's going on and some of the differences and the need to do the bright line separation between commercial collection and use of data versus government collection and use of data. We will talk a lot about that. I will talk a lot about that. But I don't want to underemphasize, or I don't think it can be overemphasized that things have changed, and I don't know what I'll receive in terms of a reception to the messages that I have previously been quite successful at giving in Europe about how good we are at privacy, even though it's different, we do it very well. I don't know what I'll receive over there. But there is one message I have been giving to companies here, and if you give me 2 seconds, I'd like to say this too. I agree, as I just said, that we need to talk about commercial collection and use of data separately from government collection and use of data. I think that's very important. Yet on the commercial side, I would like to see businesses in the United States recognize that there is more that they can do to protect privacy. We heard Chairwoman Ramirez talk about this yesterday. I've been talking about this for years. There are many proposals that are on the table in terms of do not track, in terms of what I call reclaim your name, what the full agency has called the portal for data brokers that should be used so consumers can know more about data collection and use that's invisible to consumers. There are many things that companies can do on this side of the pond to show that they get it. And now, if any time is appropriate for doing that, I think the time is now.
Erica, and also maybe if you could, in addition to other things, if you could maybe address the interplay between the European regulation proposal and the TTIP negotiations and how they might interact with each other.
Yeah, happy to do this briefly. Maybe just one word to what Luigi said. I think the idea that we will have regulatory convergence, this is not going to happen between Europe and the United States. Like it's true, it's not going to happen with other parts of the world because we have different history, regulatory history, different philosophies, how one wants to regulate. That's why I think the really best approach would be like Luigi, we did in many other sectors, is really to ask for interoperability or for mutual recognition agreements in the future. So there are different ways of dealing with differences. And we are actually quite familiar in achieving positive and good results. Not in all areas, but primarily, and when you look back in the past, we succeeded actually quite well in very conflictual areas. And so would be not the first time that we would find more harmony between us. And this is true for European companies as well. What we tend to forget sometimes is that European companies need this more unified regulatory environment as well. So it's not just important for countries from third countries, but it's important for European companies as well, because they have a very fragmented business environment as well right now. So that's why this idea of a more harmonized approach and a one-stop shop system and the data privacy environment is so important and so relevant. So I don't think so there are big differences actually between European and American business, how they see this. There may be certain sectors in the European business environment which have a harder time than others, and this is probably true for the telco environment, but it's not true for the software environment. It's not true for the big other players in Europe. So one has to be really watch this carefully, the differences. How does this reflect to the TTIP? I think what we will see, in the beginning there was this idea that one could align the data privacy regulation with the timetable with the free trade agreement between Europe and the United States. I don't see this happening. I can't imagine it's going to work out. I mean, just because the discussions will be very different, and so to align the two timetables, I think it's not really helpful. But I would encourage both sides actually to look into, if not certain provisions, could be at least debated, so that certainly trade barriers, like we could face some trade barriers coming out of regulation. So this should be discussed at least. It should be looked at if there are not certain provision in the e-commerce environment. One could consider and can look at and could argue, that certain provisions could be embedded, data privacy provisions could be embedded in the trade environment. There are examples when you look at the Korea agreement, the EU-Korea agreement. There are already little pieces embedded. So one could go a little bit a step further, but one has to take this, I think, very carefully, because you don't want to overburden, both discussions and dialogue. So one has to be very realistic what is achievable.
May I make just one comment? But let's be clear on one point. I think all of us agree that there are differences between Europe and US. Okay? I think we agree on this point. I'm referring to the commercial side, not to the rest. So if we agree that there are differences, we believe that such kind of differences are creating a disparity with the European company and are putting the European company in disadvantage. So that's the point from our point of view. Now, what does it mean in concrete interoperability? Because it's a very important word. What does it mean? So it means that we continue to keep these differences, and we continue with the fact that the European company have some disadvantages. So this is from our point of view, and what we would like to see. But this is not only from the company, because we see that who is using the service is the consumer. When European consumer goes on the net and uses internet, he doesn't know if the server is in Europe, and he doesn't even care if the server is in Europe or outside. And he believes to have the same level of protection, independently where the server is offered. And I think this is what we should look at. Regarding the relation with TIP, I think we believe that this should not be is not a trade barrier. It's not a trade barrier, and under the Article 14 of the GATT service should not be discussed in the TTIP. But also would be very interesting to know what is the view of the other panelists.
Yeah. And then we'll go to the audience. Okay.
Should I?
Well, Bernie has his hand up. Yeah,
Sure. a couple of points. I mean, the reality is if we step back and we look at, let's just take the last 150 years of trade policy, there are all kinds of non-tariff trade barriers, whether it was required ships and cargo carriers for transporting goods, whether it was required domestic content in manufacture, whether it was required, go through the list of non-tariff trade barriers. Every country engaged in them to a greater or lesser degree, depending at any point, snapshot in time. In an information economy, the modern non-tariff trade barriers are going to be about the transit and access and use of information and the technologies that provide those services and the transport to do them. It's a reality. The bricks and mortar economy will never go away, but just like the combustion engine superseded the horse, just like plastics and other synthetics began to coexist with natural fibers and materials. We are entering an era, and we are well into it already, of a 21st century information new economy that is turning the world into a global village. That's reality. And so I think it's difficult if we're going to have a modern trade agreement, whether it's between the US and Europe or any place else in the world, to not recognize that's part of this picture that we're looking at. And the citizens of both countries or sets of countries, depending on what type of agreement we're talking about, will equally be affected by the outcomes of policy. In that sense, I would suggest consumers and small businesses in the United States, in Canada, have the same interests as consumers and small businesses in Europe, or in Africa, or in Latin America. People are people. Small business is the backbone of every economy in the world. And there is a democratization impact, both in terms of access to information and in terms of economics, that is in the process of changing the world. Some governments feel threatened by it. Not the governments we're talking about in this discussion today, but that's a reality. Others are trying to figure out policy answers and balance for their citizens. And every country is different. Every country's social makeup is different and has to be respected by every other country. That's how we have a peaceful, harmonious planet. But we also have to recognize the commonalities and the common expectations that people have. It's not just about technology and where it resides, but it's what they have access to, what they can do with it, their ability to do the same thing that their neighbors on the other side of the planet can do to prosper and to get access to information and knowledge. You know, there's a lot of talk about legislation in the United States to firm up or add to the existing privacy regimes and existing regulatory structure. Realistically, it is difficult to get even a budget out of the United States Congress to run the federal government. And I don't say that derisively, it is simply an observation of reality. It has become extremely difficult to get legislation to go through both houses of Congress, through conference, arrive on a president's desk, any president's desk, get it signed into law. It happens fairly rarely now. Whether that should change is something US citizens can talk about and politically debate, but we have to recognize that's our current reality. I would suggest banking our hopes on further defining and maturing privacy policy on legislation as something that is not attainable in the foreseeable future. The administration's initiative with a multi-stakeholder process, which as far as I could hear hasn't yet really been talked about at the conference here, we would suggest is extremely important. And developing and coming to agreements on best practices that are then enforceable by the FTC on the participants and signatory companies adopting those practices is an excellent alternative method of adding to and enriching our policies in this country when legislation is not a likely prospect, not because of the topic of privacy, but because of the topic of legislation. So the reality is there's an opportunity here to put our best foot forward, and that multi-stakeholder process deserves support and engagement. You know, we as a company, and we are not exclusive in this, but it matters because it goes to the fabric of who we are at Intuit, believe that our customers' data belongs to them. And we are the trusted steward of that data in providing services to them to economically empower them. Our software provides financial management and tools to consumers and small businesses to help them improve their financial situation. That concept of respecting the individual and the small business, but also then, together with them, empowering them with the tools and the power of the 21st century information economy to improve their personal situation and their family situation, we suggest is intertwined. It is part of serving those customers well and meeting their expectations, not to take advantage of them, but to serve them and meet their expectations. Respecting that people's data belongs to them and that we are accountable is a core principle. Moving forward into principles-based best practice agreements that are enforceable in various aspects of privacy, various questions and issues, various technologies, which has begun through the multi-stakeholder process, is worth the time and investment of both government and industry alike.
Okay, let's try to bring the audience into this. Chris.
Thanks, Tom. Chris Wolf from the Future Privacy Forum and Hogan Lovells. This was a terrific discussion, and Alan, thanks for the shout out. I wish you were back in government for a number of reasons. One, so you wouldn't be such a vigorous competitor with our practice, but also because you're really truly very articulate in sort of covering the landscape, as were other panelists, and talking about U.S. Protection of privacy, and dare I use the term adequacy, which is the term that the EU uses to determine whether or not we are worthy of cross-border data flows. And we've talked about the TTIP, and I helped organize the Coalition for Privacy and Free Trade, and we welcome any members who might want to join that. That's kind of a long-term play. It's going to take several years. The Obama administration wants to do it on the so-called one tank of gas. We'll see whether that happens. That discussion is going to continue, but it seems to me right now we have a much more serious issue, and Commissioner Brill adverted to it, as did others, and that is the threat by the European Union to exercise what in the privacy world is the nuclear option, and how we address that. You know, under the current directive, we get cross-border data flows only at the discretion of the European Union under its adequacy finding. The Safe Harbor Agreement is pursuant to that adequacy finding. They could withdraw it tomorrow. And the disruption to commercial trade and to cross-border data flows and interoperability would be enormous. Now, we don't know whether this threat is serious or not, but my concern and my question for the panel is, who's speaking to address the threat with the facts? The facts about national security access to data, which is, as Bernie pointed out, you know, just as robust, if not more so, in Europe, and perhaps without the due process protections we have here. You know, say what you will about their effectiveness, but in some places in Europe they don't exist at all. Commissioner Brill and Danny Sepulveda are going to go to Europe, and Ambassador Gross probably could speak to this as well. There's a certain amount of diplomacy that goes on in those meetings. But who is going to speak on behalf of the US government in really pushing back affirmatively with the facts to what really has been propaganda in the last several weeks, which has the potential of undermining the current cooperation, but also the long-term play of the TTIP. And I'd be interested in the panelists' views.
Julie, are you going to speak on behalf of the U.S. government?
Well, I can't. I mean, we're an independent agency. You know, I was appointed by the president and confirmed by the Senate, but that's the end of our relationship in theory. Seriously, we are independent. I do spend a lot of time talking about what we do with respect to commercial collection and use of data and how we engage in enforcement as well as promoting best practices. Bernie, I'm really glad you raised the multi-stakeholder issue. And we haven't really talked about innovating on behalf of privacy yet, but I think that to a certain extent, that's a lot of what the multi-stakeholder process is about. And I talk a lot about that with my European counterparts because there is some mention of industry codes in the proposed reg as well, and trying to flesh out with them whether they have the same understanding about what industry codes mean as we do. From my perspective, I think they need to be enforceable to be meaningful, and that's why I completely agree that they need FTC enforcement as a backstop. But in terms of, to directly answer Chris's question, I do think there are a lot of people who are talking at all sorts of levels about the national security collection and use of data on both sides of the pond. I think it's, starts with the mission, the U.S. mission to the EU. I think it's happening at the ambassadorial level, and I think it is also happening through the State Department. I have every reason to believe it's also happening with respect to the Commerce Department. But there's a certain change in personnel going on, both in terms of the ambassador, our ambassador to the EU, Bill Lenard, who is a tremendous spokesman on behalf of the United States, and a really tremendous guy, has understandably retired from that position. And similarly, Cam Carey is also about to depart, General Counsel of the Commerce Department, both of whom have engaged a lot in this discussion. I have no doubt that those discussions will continue, but they're going to have to be picked up by their successors. But it is not, so I'm sort of, I do the best I can with my remit, and my remit is incredibly important, I believe, but I do not personally, I have not yet, I should say, gotten into that debate over here's what we do, but let's talk about what you guys do on the government collection and national security side, because it's, just not what we do.
So, Alan, how concerned should we be about the nuclear option?
Well, I think it's very serious, and I think Chris has expressed the risks very well. And I think it is entirely telling that it is not clear to the experts in this room who is speaking for the United States, who is advocating our interests on privacy, data protection, data flows in connection with the PRISM, Snowden, treachery, revelations, whatever you want to call it. The fact of the matter, the reason that it is not clear is we do not have a focused spokesperson or authority for the United States who can address the national security side and the privacy side. And in the United States, our government officials, be they more responsible or more constrained, they stick to their remit, to use Julie's words, more than they do in the European Union. The data protection authorities, who are, and the DG Justice and the European Union Commission, whose remit is personal information privacy outside of the national security law enforcement realm. They have no responsibility for that. They are not hesitant or constrained for a second to address the U.S. government national security data collection, even though they have no responsibility for it. So on the U.S. side, our key privacy officials, the Federal Trade Commission, Commerce Department, elsewhere, they stick to their remit. They only talk about consumer privacy. The conversations that are going on between, our national security, Department of Justice has been involved, but they're at a lower level. They're not taking a high role, and they're not able to address the privacy concerns that are expressed by the data protection authorities. And so they could go nuclear in the European Union because the privacy regulators are not talking to our government national security folks, and they're not talking to their government's national security folks. It should be borne in mind that national security and serious law enforcement data collection in the European Union is completely carved out of the data protection directive. At present, it would be completely carved out of the proposed regulation, and under the Lisbon Treaty, national security, serious law enforcement is a competency that is apart from the privacy regulators. So the right people are not talking to each other. The data protection authorities in the European Union are willing to talk about Snowden. Our commercial privacy regulators, personal information privacy regulators, are not willing to go beyond their remit and say, wait a minute, let's not mix these apples and oranges. I think that's the problem.
Okay, so just thank you, Tom, for letting me respond quickly, because I know we're sort of out of time. Look, I understand my job, I understand my limitations. I think that there are a lot of people in this room who are constantly telling me, Julie, here's your boundaries, don't go beyond them. So it's sort of interesting to hear someone say, no, go beyond them, go beyond them. But let me be real clear. I think that this conversation about government use of data is incredibly important. I want the right people to be able to answer the questions of the data protection authorities. And I was instrumental in getting David Medine, our new Private Civil Liberties and Oversight Board chair, to come to the conference that's going to be taking place next month in Warsaw. So he'll be at the closed session talking to the data protection authorities about what the Privacy and Civil Liberties Oversight Board is doing with respect to a lot of these new revelations and their analysis and work that they're going to be engaged in. So I think it's very important, I agree, to get the right people there. I think the State Department is also very capable of discussing both sides of the coin, as Alan has put it, and I've also been instrumental in working with them to get them in touch with the right people. So, I don't think it's fair to say that there's nobody aware in the US government of this issue. I just think it's important that the right people engage in this discussion. And I think David Medine, the new chair of this Civil Liberties Oversight Board, is an instrumental person, as is the State Department. One other thing I want to say, just really, really quickly, the reason why it's very important to continue to have the FTC involved in this discussion, however, is we enforce the safe harbor. And one of the things that I've spent the last 1 to 2 years talking to my European counterparts about is the fact that we have been engaged in aggressive enforcement of the safe harbor. We have our Google settlement, our Facebook settlement, our Twitter settlement, and any other case that we do where we see safe harbor issues arise, we address the safe harbor issues, and the 20-year orders that we have some of these major companies under right now includes compliance with the safe harbor. So that's why it's important that we stay in that conversation. Sorry.
No, that's good. I think, but we are out of time.
Yes.
I want to stay somewhat on schedule, so I want to thank the panel and